Welcome back to Deb's True Crime Notebook, where we read the documents for you so you don't have to. So, has the defense abandoned the Odin Theory? This is a two-part series, reading the documents that were newly released from the defense. Here's part one. State of Indiana, Carroll County versus Richard Allen. Defendant's Richard Allen verified motion to correct errors. Comes now the defendant Richard Allen by counsel and files this verified motion to correct errors. For the reasons that follow, the court should either vacate Mr. Allen's convictions and or set the matters set out below for hearing. 1. In violation of the 6th and 14th Amendments, Mr. Allen was deprived of counsel at the safekeeping proceeding of November 3, 2022. That proceeding was a critical stage at which Mr. Allen was entitled to be represented by counsel, and under United States v. Chronic 466 U.S. 648, 1984, and its progeny, the court must presume Mr. Allen was prejudiced by being unpresented during the proceeding. Indiana Code 35-33-11-1 governs safekeeping proceedings for pretrial detainees and provides in full. That's 35-33-11-1 transfers for personal safety or safety of others. Upon motion of the 1. Sheriff, 2. Prosecuting attorney, 3. Defendant of his counsel, 4. Attorney General, 5. The court, alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death and represents a substantial threat to the safety of others. The court shall determine whether the inmate is in imminent danger or serious bodily injury or death or represents a substantial threat to the safety of others. If the court finds that the inmate is a danger or serious bodily injury or death or represents a substantial threat to the safety of others, it shall order the sheriff to transfer the inmate to another county jail or to a facility of the Department of Correction designated by the commissioner of the department as suitable for the confinement of that prisoner, and provided that space is available. For the purpose of this chapter, an inmate is not considered in danger or serious bodily injury or death due to an illness or other medical condition. Indiana Code 35-33-11-2 also governs safekeeping proceedings for pretrial detainees and provides in full 35-33-11-2 post-transfer hearing. Right of inmate to refuse transfer. The inmate or receiving authority is entitled to a post-transfer hearing upon request. The inmate may refuse a transfer if the only issue is his personal safety. Mr. Allen was interrogated and arrested on October 26, 2022, and booked into the Carroll County Jail under a pseudonym. The next day, October 27, 2022, Kathy Allen, Mr. Allen's wife, hired attorney Brett Gibson to represent Mr. Allen, Exhibit 1, Affidavit of Kathy Allen. In the evening of October 27th, Mr. Gibson sent a letter by email to the Carroll County Sheriff's Office and to Nicholas McClelland, the Carroll County Prosecutor, Exhibit 1B. What emerges from Defendant's Exhibits 1C and 1D is the following. Sheriff Lesenby confirmed receipt of Mr. Gibson's letter by telephone the evening of October 27th. Also on October 27th, however, over the telephone, someone at the Carroll County Jail told Mr. Gibson that Mr. Allen was not an inmate. Mr. Gibson then contacted Mr. McClelland by email, after which Mr. McClelland called Mr. Gibson on his cell phone. Mr. McClelland told Mr. Gibson that Mr. Allen was listed at the jail under a different name, an alias, but arranged for Mr. Gibson to meet with Mr. Allen. Mr. Gibson went to the Carroll County Jail, where someone from the sheriff's office took Mr. Gibson to a meeting room. It appeared to Mr. Gibson the regular jail staff did not know Mr. Allen was there. Still on the evening of October 27th, Mr. Gibson met with Mr. Allen and advised him not to discuss his case over the telephone because calls would certainly be recorded. At about 10 p.m. on October 27, 2022, Mr. Gibson called Mrs. Allen to say he would not be able to get Mr. Allen out of jail because he was going to be charged with 2 counts of murder the next day. Exhibit 1, on October 28, 2022, without Mr. Gibson present, even though Mr. McClellan and Sheriff Lesenby both knew Mr. Allen was represented by Mr. Gibson. Mr. Allen was charged with 2 counts of murder, and Judge Diener held Mr. Allen's initial hearing. Shortly after his initial hearing on October 28th, Mr. Allen was whisked away from the Carroll County Jail to the White County Jail without a safekeeping order authorizing the transfer. On November 1st, 2022, a letter from Mr. Allen was mailed from the White County Jail to Carroll Circuit Court. The letter and the envelope are part of the record in this case. In that letter, Mr. Allen requested that the court appoint counsel for him. Nothing in the letter indicated he was not already represented. For some reason, although it had sufficient postage and was correctly addressed to the Carroll Circuit Court, Mr. Allen's letter requesting the appointment of counsel was returned to the White County Jail. It was then remailed from there and is filed in the court on November 9, 2022. That was an error. Under the mailbox rule, as a matter of law, Mr. Allen's letter was considered filed with the court as of November 1, 2022, the day his letter was mailed from the White County Jail. The prison mailbox rule, recognized by the United States Supreme Court in Houston v. Lack, 487 U.S. 266-276, 1998, provides that pro se filings from an incarcerated litigant are considered filed at the time they are delivered to prison authorities for forwarding to the court. Lawrence v. State, 915 NE 2D 202-205, Indiana Court Appellate 2009. The safekeeping proceeding was plainly illegal from start to finish. First, Sheriff Lesenby transferred Mr. Allen to the White County Jail on October 28, 2022, with no safekeeping order in place. Next, Sheriff Lesenby had no standing to make the safekeeping request on November 3, 2022, due to the fact that Mr. Allen had been illegally transferred to the White County Jail on October 28, 2022. Once Mr. Allen was in the White County Jail, the White County Sheriff was the sheriff statutorily authorized to make a safekeeping request under Indiana Code 3533-11-1 because Sheriff Lesenby had no standing to make the safekeeping request. Judge Diener had no jurisdiction to consider it. For example, Slosh versus City of Indianapolis, 553 Northeast 2nd, 1204, 1206, Indiana, 1990. Because Judge Diener had no jurisdiction to issue it, the safekeeping order was literally void. That's TD versus State, 219, NE 3D 719726, Indiana, 2023. A judgment is void if it grants rights or relief to a party that does not have standing to pursue the action. Second, Mr. Allen had the right to have a judge other than Judge Diener decide whether to issue safekeeping order at Lesenby's request. That is because Judge Diener had engaged in ex parte communications with Sheriff Lesenby, helping Sheriff Lesenby draft his safekeeping request in violation of Rule 3.10 of the Code of Judicial Conduct. The Code, TR June 15, 2023, hearing, Page 11, Rule 3.10 prohibits judges from drafting or reviewing documents except for family members. Judge Diener also violated the Rule 2.9 of the Code by engaging in substantive ex parte communications with Lesenby, which helping Lesenby draft the safekeeping order certainly were. Having violated both Rules 3.10 and 2.9, Judge Diener was obligated under Rule 2.11 of the Code to recuse himself and request appointment of a special judge before he issued the safekeeping order, not after, which is what he did on November 3rd, Bell v. State, 655 NE 2D 129 131-32, Indiana Court Appellate 1995, citing Inter alia Dyson versus State, 622 NE 2D 457-459-60, Indiana 1995, Shepard CG recusal opinion. See also Rule 2.11 of the Code. Comment 2, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Third, Sheriff Lesenby's November 3, 2022 request by the Sheriff of Carroll County, Indiana, to transfer inmate from the custody of the Sheriff to the custody of the Indiana Department of Corrections for safekeeping was not served on anyone. There is no certificate of service attached. Indiana Code 3533.11.1 requires a safekeeping request to be made by motion. Indiana Trial Rules 5A 2 and 3 required that Sheriff Lesenby's motion for a safekeeping order be served on the parties. Because Sheriff Lesenby knew that Mr. Gibson was representing Mr. Allen, he was required to serve Mr. Gibson with his motion for safekeeping order. Even if he claims Mr. Gibson was not representing Mr. Allen at the time, Sheriff Lesenby was required to then serve Mr. Allen personally. Fourth, Sheriff Lesenby's safekeeping request was not verified. There was therefore literally no evidence before Judge Diener from which he could make any factual finding required by Indiana Code 3533.11.1 that would authorize a safekeeping order. Fifth, because a factual finding was required to authorize the safekeeping order, a hearing with notice to the parties on Sheriff Lesenby's safekeeping request was required. Sixth, and perhaps most importantly, Mr. Allen had an absolute right to refuse being transferred to the custody of the department. Sheriff Lesenby's safekeeping request alleged no statutorily authorized basis for safekeeping order other than a concern for Mr. Allen's personal safety. If the reason for safekeeping transfer is only a defendant's personal safety, a defendant may refuse the transfer. Mr. Allen had no opportunity to exercise his right to refuse the transfer to the Indiana Department of Corrections custody or to make any of the objections set out above to the entire course of the proceeding. That is for a quite simple reason. Mr. Allen, either personally or through his lawyer, Mr. Gibson, had no notice of the legal skullduggery that would land him in solitary confinement at the Westville Control Unit in Wabash Valley Correctional Facility and Cass County Jail for 23 months pending trial. Because Mr. Allen had no notice of what was afoot, neither he nor his lawyer could make any of the arguments that would have necessarily prevented Mr. Allen's transfer. Finally, Mr. Allen's own absence from the safekeeping proceedings should not be treated differently from the absence of a lawyer to represent him. Indiana courts hold pro se litigants to the same standard as trained lawyers. Zavodnik versus Harper, 17 NE 3D 259266, Indiana 2014. One consequence of this should be that the Sixth Amendment and Article 1S 13A of the Indiana Constitution should apply when a pro se litigant is excluded from a proceeding at which he or she has the right to be present and participate in. It's a violation of the Sixth Amendment to completely deprive a defendant of counsel at any critical stage of a criminal prosecution. United States versus Chronic 466 U.S. 648 659 1984. The safekeeping proceeding, such as it was a critical stage at which Mr. Allen had a Sixth Amendment right to have his lawyer interpose all the objections to the November 3rd safekeeping order set out above. Bell v. Cone, 535 U.S. 685 696 2002. A critical stage is one holding significant consequences for the accused. Accord, Woods v. Donald, 575 U.S. 312 315 2014. Per curiam. Because Mr. Allen was entirely and unconstitutionally deprived of counsel at the safekeeping proceeding, the court must presume Mr. Allen was prejudiced by the deprivation of counsel. Chronic 466 U.S. at 659, Accord Garza versus Idaho, 586 U.S. 232 237, 2019. Alternatively, Article 1 S13A of the Indiana Constitution provides in part, in all criminal prosecutions, the accused shall have the right to be heard by himself and counsel. Section 13A affords citizens ever greater protection than its federal counterpart, Caraway v. State, 891 NE 2D 122 126, Indiana Court Appellate, 2008. Not only does 13A guarantee a criminal defendant the right to counsel at any critical stage of the prosecution, but the rights afforded under Section 13 also attach prior to the filings of formal charges against the defendant. Hall v. State, 870 NE 2D 449460. And this is a footnote on the page. The court need not speculate whether safekeeping proceedings have serious consequences for an accused. In addition to being moved hours away from his lawyers for over 23 months, Mr. Allen was unconditionally kept in solitary confinement in an Indiana Department of Corrections prison and was shackled, leashed, and hooded and deprived of human contact. See Wolf v. Bell, 441 U.S. 520, 53537, 1979. Violations of due process for pretrial detainees to be kept in conditions amounting to punishment. As a consequence of that torture, Mr. Allen became psychotic. Short of his death, it is hard to imagine more serious consequences for Mr. Allen flowing from the November 3rd safekeeping proceeding. Trans denied. See also Taylor v. State, 689 NE 2D 699703-04, Indiana, 1997, recognizing that right to counsel attaches upon arrest. Mr. Allen was not afforded either the right to be heard by counsel or by himself at the safekeeping proceeding. This should be particularly disturbing because he had been given the opportunity to do so. Mr. Allen had an absolute personal right to refuse the transfer to the department's custody. In either case, accordingly, the court should vacate Mr. Allen's convictions or set this motion for a hearing. 1. In violation of the Due Process Clause of the 14th Amendment and Napiew v. Illinois, 360 U.S. 264, 1953, and its progeny, the state presented the testimony of Brad Weber that Mr. Weber arrived home in his white van at 2:30 p.m. on February 13, 2017, either knowing the testimony was false before it was elicited or failing to correct it once it had been elicited. A. Conviction obtained through use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. The same results when the state, although not solicited false evidence, allows it to go uncorrected when it appears. Napiew v. Illinois, 360 U.S. 264, 269, 1953, citations omitted, accord Smith v. State, 34 NE 3D, 1211, 1219, Indiana 215, Story v. State 243, NE 3D, 1108, 1117, Indiana Court Appellate 2024, trans denied. At trial, the undisputed evidence was that Libby German's cell phone, telephone, stopped moving at 2:18 p.m. on February 13, 2017 for 7 minutes until 2:25 p.m. Then it started moving again and stopped moving permanently at 2:32 p.m. In closing argument, Mr. McClellan called it a hard fact that Libby German's phone stopped moving at 2:32 p.m. The state introduced an alleged confession by Mr. Allen to Dr. Monica Walla, a psychologist contracted by the Indiana Department of Corrections to treat inmates at Westville Correctional Facility. In this alleged confession, Dr. Walla stated, Mr. Allen said he abducted Libby German and Abby Williams on the south side of the Monon High Bridge and forced them down the hill to the south side of Deer Creek. Dr. Wallace said Mr. Allen was on the south side of Deer Creek and was planning on sexually assaulting Libby German and Abby Williams when he was interrupted by a van. Dr. Wallace said Mr. Allen said he became scared when he saw the van and crossed Deer Creek from south to north from the Weber property to Ron Logan's property, taking Libby German and Abby Williams with him. The state also introduced the testimony of Brad Weber that he left work at the Subaru factory in Lafayette, Indiana at 2:02 p.m. on February 13, 2017 and arrived home in his white cargo van at about 2:30 p.m. From Mr. Weber's testimony, the state argued Mr. Weber's arrival home in his van was interrupted, Mr. Allen causing him to take Liberty German and Abby Williams across Deer Creek to kill them on Ron Logan's property. The arrival of Mr. Weber's van at about 2:30 was a detail only the killer would know, said the state. But the problem is the state also contended that Liberty German and Abigail Williams died near the time to 2:32 p.m. when Apple Health data from Libby German's phone showed that the phone stopped moving. If the arrival of Mr. Weber in his van interrupted Mr. Allen, forcing him across Deer Creek, Mr. Weber would have had to have arrived near his parents' house at the end of the private drive before 2:32 p.m., when, according to the state, the phone stopped moving and was located on the north side of Deer Creek. In fact, Mr. Weber would not have arrived anywhere on the private drive before 2:44:54 p.m. on February 13, 2017. His arrival at about 2:30 would not have been a detail only the killer would know, because it did not happen. The state knew or should have known as much, and the state either elicited Mr. Weber's testimony about the time he arrived home, knowing it was false ahead of time, or failed to correct the testimony once it had been elicited. Defendant's Exhibit 3A, as attested to by Matthew Hoffman in Defendant's Exhibit 3, is a video recording made by or on February 13, 2017 by a security camera that was in the house of 5998 West County Road 252 North. The video recording was provided to the defense by the state and has therefore been in the state's possession. Exhibit number 3. The security camera faced northwest, and appears to have recorded continuously, ID based on the date and timestamps on the video. It appears that the security camera was set to record date and time information as part of the recording. The time on the security camera was set 12 hours behind, such as 12 a.m. is really 12 p.m. on the same day. This is apparent due to the daylight and moonlight on the video and the associated timestamps. The security camera had a wide-angle lens that captured video of traffic on West 252 North and County Road North 625 West, and the beginning of the private drive to the Weber property, which begins as a continuation of North 625 West. Approximately 190 feet off that road's intersection with West 252 North. County Roads North 625 West and West 252 North are the only roads by which a vehicle could enter the Weber property. According to the time and date stamps on security camera recording, Exhibit 3A shows a white vehicle going north on North 625 West, entering the frame at approximately 2:44:33 p.m. on February 13, 2017. Exhibit 3A also shows a white vehicle continuing into the private drive to the Weber property at approximately 2:44:54 p.m. Exhibit 3A is viewable on the YouTube at the following address. And the address is there if you want to type it in and watch the video. It's a YouTube channel. Exhibit 3B is a video file that contains 3 zoomed clips from the video recording. That is Exhibit 3A. Each successful clip in Exhibit 3B is zoomed to a greater magnification. Example 3. Exhibit 3, in all 3 zoomed clips of Exhibit B, a white cargo van going north on North 625 West just after 2:44:33 p.m. on February 13, 2017. Exhibit 3, Exhibit B, is viewable on YouTube at the following address as well. And the address again is there if you'd like to view it. Exhibit 3C is a PDF with still photographs taken from Exhibit 3B at each magnification level. Exhibit 3 for each magnification level, zoom level 1, zoom level 2, zoom level 3, and there are 3 stills showing the white cargo van just before it passes the white sunlit house in the background on the west side of North 625 West as it blocks the sunlight house, and 3 just after it passed the sunlit house. Reproduced below is the first still photograph on page 3 of Exhibit 3C. Now, you can also go to the video that I did before this one, and that video is on my video about midway through. Below is Exhibit 3C showing circled a white cargo van before it passes the sunlit house on the west side of North 625 West. Exhibit 3D is a photograph of Brad Weber's white cargo van provided to the defense by the state and therefore has been in the state's possession. The photograph of Mr. Weber's white cargo van in Exhibit 3D appears to be at least similar to the white cargo van as it appears in Exhibits 3B and 3C, the zoomed video clips and zoomed still photographs created from Exhibit 3A, the original security camera recording. Other video files produced by the security camera in the state's possession provided to the defense in discovery and covering the time from 2 p.m. to 4 p.m. on February 13, 2017 do not show any other van driving north on North 625 West into the private drive to the Weber property or traveling east on West 252 North during that time. 30. Exhibits 3A, 3B, and 3C reflect that if Mr. Weber returned to his home in his cargo van, he could only have arrived some minutes after 2:44:54 p.m. on February 13, 2017, 12 minutes after the time the extraction of Libby German's cellular telephone shows the telephone stopped moving at 2:32 p.m. Either the white cargo van showed in Exhibits 3A, 3B, or 3C as Mr. Weber's, with him arriving home some minutes after 2:44:54 p.m. on February 13, 2017, or it is not. In either event, no white cargo van or any other van entered the private drive to the Weber property at 2 p.m. and at or before 2:30 p.m. on February 13, 2017. The time the extraction of Libby German's cell phone telephone shows the telephone stopped moving. The defendant's Exhibit 3E is a redacted FBI subject information sheet for Bradley Weber and is dated March 3, 2017, Exhibit 3. The unredacted version of the Exhibit 3E was provided by the defense by the state and was therefore been in the state's possession. Exhibit 3E, the FBI subject information sheet for Mr. Weber, says on February 13, 2017, Weber's phone pings to parents' address overlooking crime scene initially at 2:50 p.m. and repeatedly pings around the property until 11:55 p.m. That Mr. Weber's phone first pings to his parents' address at 2:50 p.m. on February 13, 2017 is consistent with the video evidence in Exhibits 3A, 3B, and 3C showing that Mr. Weber could not have arrived home in his white cargo van until sometime after 2:44:54 p.m. that day. From both Exhibit 3A, the security camera video recording, and Exhibit 3E, the FBI subject information sheet for Mr. Weber, the state either knew that Mr. Weber's testimony about the time of his arrival home would be false before it was elicited or failed to correct it once it had been elicited. When the state introduces testimony it knows will be false or fails to correct testimony it knows or should know to be false once elicited, a conviction must be vacated or reversed if the false evidence may have had an effect on the outcome of the trial. NAPU 360, U.S. at 272. See also United States versus Cardina 842 F3D 959 976-77 7th Circuit Court 2016. Receive a new trial. The defendant must show that there was a false testimony, that the government knew or should have known it was a false, and that there is a likelihood that the false testimony affected the judgment of the jury. United States versus Freeman 650 F3D 673-678 7th Circuit Court 2011. To obtain Mr. Allen's conviction, the state explicitly replied on Mr. Weber's testimony about the time he arrived home and used the testimony to corroborate Dr. Wallace's rendition of Mr. Allen's statement that he became scared after he saw a van, so he took the girls to the north side of Deer Creek and killed them. This was the only statement allegedly made by Allen that contained any detail of the murders that might be true. The state therefore cannot show Mr. Weber's uncorrected false testimony about the time he arrived home did not have an effect on the outcome of the trial. NAPU 360 U.S. at 272. Alternatively, were the court to find that the state did not know or should not necessarily have known about Exhibit 3A, the security camera video, and Exhibit 3E, the FBI subject information sheet for Mr. Weber, then both exhibits constitute newly discovered evidence that would probably produce a different result at a new trial. Accordingly, for either reason, the court should either vacate Mr. Allen's convictions or set this motion for a hearing. So let's recap a couple of things from what we heard here. Number one, it's very possible that the reason that Richard Allen's first attorney could not locate him at the jail was because he was in there under an assumed name for his protection. And the person working clearly did not understand that. So I don't think that was any effort to hide him from his attorney. I think it's just a weird thing that happened. And number two, there is also a part in here where it talks about the false testimony, alleged false testimony of Brad Weber. And it talks about the fact that if that is false testimony, then it negates the judgment and there should be a new trial, or the client's conviction should be reversed. Well, it also says that to get a new trial, the defendant must show that the false testimony affected the judgment of the jury. So that's something you need to think about. The time is different for sure. It is possible it could have affected their thinking, but again, you go back to no matter what time he arrived there, Brad Weber arrived, Richard Allen did point out that he saw a van come by and that scared him off, and he left and went across the creek with the girls. So even though the time is not exact, it's a 12-minute difference, the premise of it still stands. So would a jury have figured that out? Would they have looked at it and said, no, the time is too much of a doubt, so therefore reasonable doubt, mistrial, or hung jury? I guess we'll never know that. So we'll see if the Supreme Court decides that this is something to be looked at as an appeal, and we will get into part 2 of this video tomorrow. That concludes part 1 of this 2-part document that is very lengthy and was written by Andrew Baldwin. We will get into part 2 tomorrow. In part 2, it talks about Ron Logan and the confession of his cellmate, Ricky Davis. Now, Ron supposedly confessed to Ricky, and we'll get into all of that tomorrow. So be looking for that video sometime tomorrow afternoon. We'll see you next time on Deb's True Crime Notebook. Don't forget to like, subscribe, ring the bell for all notifications, share this in your groups and with some friends, and don't forget to leave a comment. We'll see you tomorrow with part 2.